Hi, my name is Aaron Lacey, and I'm the chair of the higher education practice at Thompson Coburn LLP. And you are listening to Title IX Investigations and Informal Resolutions, which is part of the Thompson Coburn Title IX training series. Thompson Coburn, for those of you who may not know, is a law firm. It's a big one. We have offices around the country, and we have a higher education practice. So these are lawyers in our firm who specialize in working with institutions of higher education on a wide range of matters, including those involving discrimination on the basis of protected classes. So discrimination on the basis of sex or race or disability or something along those lines. We are really pleased to be bringing you this training series. I'll be brief. Some of you may have already listened to a couple of our sessions before now, so I'll try to get through this in a concise way. But the purpose of this training series is to offer professionals at institutions of higher education who may now be part of a new Title IX process at their institution an opportunity to get some foundational concepts, right? So this new rule, this new Title IX rule becomes effective August 14th, 2020. And among other things, it's going to require colleges and universities to put into place a fairly robust and in some cases quite technical process for managing formal complaints of Title IX sexual harassment. And that means you've got adjudicators and advisors and investigators and all types of different persons who are going to be pulled into that process. And of course, they're going to need a certain amount of information. And one of the things the new rule requires is that all those individuals be trained and that institutions of higher education make the training that they use available. So we wanted to make this training series available to you all to use. Of course, we're very happy for schools to use it widely. It is free. You can put it on your website. That's why we created it. We are in different places, as you'll see today. This is being recorded in July 2020, so in the midst of the COVID-19 pandemic. And we know in this time period, it's extremely difficult to get folks together and to get training accomplished. So that's one of the reasons we wanted to put this training together for you so that you would have something easy and accessible that you could use. So please feel free to use it at your discretion. If in addition to the foundational training, you would like us to work on some custom training for you, of course, we would be happy to do that as well. The training series is comprised of 6 modules. Today, we're going through module 3. So you're almost halfway through the series. You will be when we get to the end of this. And at the beginning of each training module, you'll see this same graphic here on your screen. And as always, the box that's highlighted orange tells you where you are. This is the syllabus for today's session, right? So this is what we'll be walking through today. I will start briefly with the formal complaint framework, which is a sort of a recap we'll do at the beginning of every session. And then after that, we're going to start to get into the nitty-gritty, as they say, of investigations. The folks who are going to take you through that process, I'm pleased to say, are 2 colleagues of mine, friends and colleagues, I should say. Susan Lawrence, one of them a partner in our HR employment law practice, who has many years of experience managing investigations of discrimination in all types of settings, including in institutions of higher education. And Susan's going to bring her wealth of knowledge and information to us. And really, we are grateful, bring a lot of the experience that comes and you only gain really out of going through investigations. Scott Goldschmidt, who you've seen if you've already watched some of these, and you'll see some more, is also part of our higher education practice. Scott was formerly the Deputy General Counsel at Catholic University in Washington, D.C., was there for about a decade, and during his tenure spent a lot of time thinking about new Title IX policies and working with faculty and staff and others on Title IX and other related matters, all those types of things that general counsels do. So I wanted to start today. I mentioned here the first stop on the syllabus is the formal complaint framework. And really the idea here is at the beginning of every session to sort of bring you back in and give you a little bit of a recap so you remember what we're talking about. So the Title IX statute, and on the off chance you didn't watch the first couple of training modules, is the statute created by Congress in 1972 that is specific to institutions of higher education, or I should say institutions of education, also applies to elementary and secondary schools. But with regard to colleges and universities, prohibits the discrimination on the basis of sex on campus, right? And you'll see here, and we wanted to remind folks, you know, for a very long time when we thought about Title IX, many of us tended to think about equity in athletics, but it is much broader than that, right? It prohibits discrimination on the basis of sex in all programs and activities at an institution. Importantly, it also covers both students and employees. So it's not just about athletics. It's not just about students. It's pretty broad, and it prohibits, again, discrimination on the basis of sex throughout the institution. There is a Title IX regulation. So the statute was created by Congress, and Congress said, hey, we have this basic important concept, and now U.S. Department of Education, Office of Civil Rights, we want you to go create a regulation that's more robust, has a lot more detail, really helps institutions understand what they're supposed to do and what they're not supposed to do. So way back in 1975, not long after the statute was created, the U.S. Department of Education created its first big Title IX regulation. And it is robust, and it goes on at length and talks about all the different things that schools have to have. Among those, sort of the core requirements: a non-discrimination statement, appointing a Title IX coordinator, as you'll see on your screen, grievance procedures. So you got to have a process for managing complaints of discrimination on the basis of sex, and you have to take action to remediate or address and prevent discrimination on the basis of sex. Where's the new rule fit in? So a couple of years ago, this administration said, you know, we've had a lot of guidance. Some of that they agreed with, some of that they did not agree with. And we talk about that in the first training module in more detail. But this administration said, what we have not had really since 1975 is a new regulation, right? We've had all this guidance and back and forth on sort of at the sub-regulatory level, pamphlets and things along those line, dear colleague letters saying, this is what we, the current administration, think, but we haven't had an actual regulation. So this administration said, we're going to create one. It's been controversial. When they put out the proposed comment, there were the proposed rule, there were over 120,000 people who commented. And then earlier this year in 2020, they put out the final rule. In its unofficial format, it was over 2,000 pages. So it was big and complicated, and this administration had a lot to say. If you click on this square, the same place where these videos are housed, hopefully you don't, without too much trouble, can find copies of the slides, PDFs of the slides themselves. And these are active links throughout the presentation. And one of the things you can do here, for example, is click on this little box and it'll take you to the Federal Register if you want to check out the new rule and all that commentary that went along with it. I mentioned earlier, institutions have until August 14th, 2020 to absorb and implement this new rule, which if you feel like that's a really short time frame, you're not alone. I can assure you of that. So the last slide here, and this graphic is in every presentation, and the last thing I want to sort of emphasize before handing it off to Susan and Scott is just to help you understand and remind you that the focus of this new rule really largely is on formal complaints of Title IX sexual harassment. So I mentioned at the outset, the Title IX statute prohibits discrimination in institutions of higher education and all educations and all programs and activities. And when we talk about, again, discrimination on the basis of sex, we mean anything outside of sexual harassment. That could include in promotions or recruiting or employment criteria or housing or all of those different kinds of facets of your institution. So that's the big box. That's the Title IX statute. You can't prohibit, you can't discriminate on the basis of sex. And then within that, right, and the new rule addresses this a little bit, we have this more specific concept of Title IX sexual harassment, right? So you have discrimination on the basis of sex, which is sort of the biggest of the umbrellas. And then within that, you get to Title IX sexual harassment. And that's a specific thing. And there's a specific definition in the new rule of sexual harassment as it's conceived in the context of Title IX. And we talk about that at length again in the first training session or module that's part of this series. But finally, and this is the point I want to emphasize, right? The new rule is really focused on what institutions are supposed to do when they get a formal complaint of Title IX sexual harassment. So that's when either a complainant or a Title IX coordinator actually submits a written complaint alleging sexual harassment and requests an investigation. And most of the rule is really focused on what you should do as an institution if you get that formal complaint. And most of you who are watching this video, we expect, are going to be involved in that formal complaint process, right? If you're an adjudicator, an advisor, an investigator, that's really when your role comes into play. So with all of that having been said, just keep in mind what we're talking about today are best practices, requirements, foundational concepts if you are involved in an investigation, right, that occurs subsequent to receiving a formal complaint of Title IX sexual harassment. There is a definition of formal complaint. It's in our prior presentations and it's in this one as well. I just went over it, but if you want to sort of break it down, you can come back and look at this slide. And finally, just to highlight the extent to which, and this graphic's in all our presentations too, the extent to which the new rule is really focused on this formal complaint framework. All of these different elements that you see on the screen right now, these are all the things that the new rule says in 106.45, if you look at the citation at the bottom. These are all the things the new rule says have to be included in your policies and your processes for dealing with formal complaints of Title IX sexual harassment. And you can sort of see from the graphic here, you have all these different components. The ones in orange that are highlighted, those are the ones that we'll be talking about today. Notice of allegations, investigation, and formal resolutions. And we're addressing all these other components in the other modules that are part of this series. So with all of that having been said, I will turn it over to the very capable Ms. Susan Lawrence and Mr. Scott Goldschmidt. Take it away.
So here we're going to introduce some key concepts for the presentation. We'll just kind of briefly outline them, and then throughout the rest of the presentation, we'll kind of go into more detail of what we want to kind of explain here about these concepts in depth. So the first, hopefully, if you've seen the other presentations, this is the theme throughout. The department is really concerned, rightly so, treating complainants and respondents equitably. So that is a feature of throughout the process, and certainly for investigators and informal resolutions, that is important to keep in mind too. The second one is the requirement to objectively evaluate all relevant evidence. We're going to go into what we consider relevant evidence, and explanation of that, and an explanation of both inculpatory and exculpatory evidence, what they mean a little bit later. But it's also important to note that you need to provide that credibility determinations are not based on a person's status as a complainant, respondent, or witness. So the department's clear that just because someone's a complainant doesn't mean that you should inherently believe or not believe them. Same thing with a respondent, same thing with a witness. Third, you need to ensure that your investigators don't have a conflict of interest or bias for or against complainants or respondents. So this is something that would be a general test. A reasonable person, you want to make sure that these individuals kind of are able to take information and equitably share it with everyone else. Next slide, please. Third, understanding the presumption that the respondent's not responsible for the alleged conduct. So here, it's important to note that until a determination is made, the respondent is not considered responsible for conduct. It's just an allegation of conduct. Next, to understand the standard of evidence. So here we have either the preponderance of the evidence or the clear and convincing standard, and schools will pick either one or the other, and we've detailed the choice there in previous slides, but we'll go over the definition of that. And last, you make sure to not require, allow, rely on, or use questions or evidence that constitute or seek disclosure of information protected under a legally recognized privilege. And we'll explain what that means, a legally recognized privilege, and what happens if a person waives that privilege. So Susan, I want to turn it over to you for the first question. I just want to get your sense. We talked about objectively evaluating evidence. What does that mean?
That's a great question, Scott, and one that judges who do this all day still struggle with from time to time, because information might not be obviously relevant and appropriate to rely upon at first glance. So what that means in sort of the technical sense is that there should be impartial consideration of available evidence, meaning that one should look at that evidence through the lens of someone who doesn't have any partiality or bias and any sort of prejudgment of that information. It also means that it should stick to evidence relevant to the facts at issue and not information that doesn't really have any place in the analysis. There shouldn't be any deference given to the recommendation of that investigator. It should be looked at through the lens of an unbiased prospect. And there should be just an overall appreciation for the fact that this is information that may be helpful or harmful, and that information should be given the same amount of weight regardless of whether the information is helpful and harmful or harmful.
Hey, Susan, this is Aaron. You know, when I think about, I look at these slides, and if I'm one of the folks watching this, I may think to myself, well, you know, it's easy to say be objective, right? This is what we're telling you. Make sure you be objective. But that's in practice such a hard thing. And I know that Scott and I have done investigations in our career. I know that you've done many more than both of us probably combined. And my question is for you, you know, does it ever get easy? Is it still hard because every time you go into a school or an organization, you know, you've got folks who already have some strong opinions about what may have happened, and you're getting a lot of information from both sides, and some of it may seem pretty dark from the get-go, and it may seem like some conclusions are foregone. How do you know, as a seasoned investigator, are there any tricks? Is there anything you do to try to prepare yourself or clear the mind or be objective? Or is it just one of those things you have to kind of discipline yourself to try to do?
I think it's the latter, actually, because we are humans and we all come at these investigations with our own personal experiences and beliefs and opinions. And it is admittedly very hard to check that at the door. I think what's important to remember is that this is not being done in a vacuum. And the information that you as the investigator look at and rely upon is going to be called to the mat as the adjudicator is looking at that information, and eventually if it results in any sort of litigation. So you have to constantly check yourself and say, how is this going to hold up? How is my reliance upon this information going to play out? And that should be sort of the touchstone that brings you back to only look at it objectively, only look at it through a sort of vacuum of this is the only information that's available to you. Because otherwise, if you aren't constantly checking yourself, personal beliefs, personal experiences are going to wind their way into it. And that truthfully is made even more difficult if the investigator is a part of this institution and might have prior experience with the people involved in this complaint process. So being very mindful, being very present, and constantly checking your approach to this information is going to be incredibly important through this process.
Yeah, it's very helpful. One of the other things we talked about was legal privilege, and that's specifically called out in the regulations. Could you walk us through what is a legal privilege, and where would this arise for an investigator? How would this come up in an investigation?
So from a 30,000 foot perspective, the law recognizes a couple of specific and discrete privileges. There's the attorney-client privilege, which people are probably well versed in. There is the priest and penitent exception and privilege, the doctor-patient privilege, and the spousal privilege. The way this will frequently play out in the course of an investigation is that if a witness or one of the parties has an attorney, you as the investigator have to be cognizant of the right that that person has with their attorney, which is to say, it would be inappropriate for an investigator to say, what have you told your attorney? You know, tell me about those conversations that you and your attorney have had. Tell me about conversations that you have had with your doctor if we're dealing with some sort of an assault investigation. And so constantly being respectful and aware of any privileges that might exist, and avoiding any attempt to invade that privilege and ask about conversations or documentation relevant to that privilege is incredibly important for the investigator.
Susan, what if you were interviewing someone, and because it may be that witnesses or complainants, respondents, they may not be aware of these privileges. And I'm just curious if you've been in situations, or what you would recommend if you're interviewing someone and they were to say, well, you know, I was talking to my doctor yesterday and we had this long conversation. Let me tell you about it. Would you stop them, or would you at that point sort of ask them, well, what was the context of this conversation? How would you handle something like that?
I would stop them first and remind them of their privilege. And only if they say they're willing to continue the conversation would I go on, because it is the right of the individual to waive that privilege, but it needs to be a waiver with knowledge and with appreciation of what it is that they're giving up.
Yeah.
Now let's go over a few key concepts, other key concepts for rest of the presentation. So the first we're going to talk about is the burden of proof. And here it's ensuring the burden of proof and burden of gathering evidence rests on the school and not the parties. And here, what we mean is that the complainant is not responsible for proving that the respondent is responsible for conduct. And conversely, the respondent's not responsible for proving they're not responsible for certain conduct. The school has the ultimate burden, the ultimate responsibility to figure out what happened here and to gather enough evidence in order to make that determination. The second piece that we want to talk about is equal opportunity. And here it's the equal opportunity for parties to present fact and expert witnesses and other inculpatory and exculpatory evidence. And this kind of gets back to what we talked about earlier about equity between the parties. What you do for one party, you have to do for the other. And also introduces a new concept of expert witnesses, which may be new for a lot of institutions, that those are explicitly permitted here. Third, schools must refrain from restricting the party's ability to discuss the allegations or gather or present relevant evidence. This might be a little bit of a new concept here. Some schools in the past did put some restrictions and prevent individuals from doing their own investigations or talking to witnesses. Here, the department says that it's absolutely not permitted. Each party has to have the ability to gather and present relevant evidence.
Scott, I actually want to put you on the spot here, if you don't mind. As of the three of us, the individual who spent the most time in-house, I'm just curious what you think about this provision. I get this question all the time from clients, colleges and universities. They say, well, we've got this issue that's arisen on campus. And the problem is my complainant and my respondent are talking with their friends and they're talking with their family and they're spreading rumors, et cetera. I assume there's a line here, right? Between not being able to prevent them from talking, so honoring this piece, but also ensuring that they don't cross the line into retaliatory type behavior. And I was just wondering if you could talk a little bit about what you think this challenge is going to be like for schools, your practical experience, and maybe highlighting that line a little bit, again, between what's them just talking and what's them engaging in behavior that might actually trigger your retaliation policy.
No, I think that's a great and important point. And a lot of schools did take the line that to restrict this behavior because of the concern about retaliation. And I think it's absolutely a real concern. It's not only retaliation, but also complainants or respondents kind of going to witnesses and trying to feed a side of the story to them, trying to get them to participate when they don't want to. There's a lot of things that could take place that could be problematic for institutions. Here, the regulation is clear that you cannot prevent them, restrict them from gathering evidence. But what you can do is inform them of your retaliation policy, which is a new requirement of the regulation as well, and just kind of let them know that you absolutely can gather and present relevant evidence, have these discussions, but understanding what retaliation is and understanding that retaliation kind of will not be tolerated in this kind of conversation.
Yeah.
So two more concepts to discuss. First, notice and timing. So you have to provide for the party whose participation is invited or expected, written notice of the date, time, location, participants, and purpose of the hearings and investigations with sufficient time for the party to prepare to participate. Hopefully, this is something that that institutions have been doing in some form or another over the past, before these regulations have been promulgated, but it is explicitly called out here, and you want to make sure that you have all these elements and potentially even a form notice that you could provide to make sure you meet all these elements. And the last is the investigative report, which we'll discuss, which includes a report that fairly summarizes the relevant evidence.
So, Susan, one of my questions for you as a seasoned investigator, I look at this first bullet in this little first line about providing to a party whose participation is invited or expected. Written notice of the date, location, participant, et cetera, for all hearings, interviews, and other meetings. One of the things that in my mind always begs the question is, well, how do we know who to interview? So we've got a complainant who shows up and says, or maybe a Title IX coordinator, somebody has made a report of an allegation of sexual harassment and has filed a formal complaint. And now you've been brought in as the investigator. And you know maybe who your complainant is, and you know probably who your respondent is, and you've talked to them, and maybe you have an idea of who some additional witnesses are. But as they talk, and as Scott mentioned earlier, as they try to corral additional people potentially to speak on their behalf, how do you as an investigator decide, what's the order of that I'm going to go in to talk to people, and how many people do I want to speak with? And, do I talk with anyone who calls me up and says they have something to say? How do you sort of vet all of that and form your game plan?
I think it's a great question, and one that doesn't have a one-size-fits-all answer. I think you need to stay very nimble as you're approaching these types of things, and be cognizant of what information do I need to get to the truthfulness of the allegation, and not just assume that it should be a scorched earth approach. If you find, after speaking to the complainant, which is always my first step, and hearing certain names that are coming up during that investigation or during that conversation, and then my usual next step, but again, usual, not set in stone, next step is to speak to the respondent. And if the same names are coming up, then that's a very good guidepost to say, those are the people we need to speak to. If in speaking to the complainant, you're hearing certain names and then others that seemingly can corroborate what either the complainant or those witnesses are going to say, it might very well be that you don't need to speak to every single person. I don't think there needs to be this understanding that you automatically have to speak to every single person that either the complainant or respondent reference, because there is a certain sensitivity to understanding that it's possible that these folks are going to have to continue to interact in the days, weeks, and years to come, and an appreciation that maybe the most disruptive approach to an investigation is not the right approach. I fear that my answer is not actually very helpful, because what you're probably gleaning is that there is no answer that is automatically the right answer. It really needs to be a thought through, well-reasoned approach, and not just every name that's mentioned is the appropriate person to speak to. I think seeing themes in the responses of the complainant and respondent is the way to approach it. And only after speaking to some of those key players, if there's an appreciation that I'm just not getting any consistency, or I need to be guided by more voices in the conversation, only then would I think to go to some of those more ancillary potential witnesses.
Yeah. Candidly, it's probably the kind of thing that you get better at over time as you do lots of investigations, knowing, sort of developing an internal sense of where those lines are drawn. But for folks who may be in this for the first time, the salient point that I really take away is, but you don't have to interview necessarily everyone. I mean, if there comes a point where you are confident that there are people who want to speak to you who have nothing new to add, you could decide not to interview those people.
I think that's right. And I don't think the mere decision to not interview someone automatically invalidates the investigation in its entirety.
Perfect. Yeah. Scott, I've advanced the slides to notice of allegations.
All right.
You have no choice.
Rocking and rolling. Let's go. So notice of allegations is the next one we'll talk about. So here we have this concept of a formal complaint, and we'll go through the formal complaint in great detail in another module, but it is a term of art that's very important to kind of know, that Aaron kind of sketched out at the beginning. But upon receipt of this formal complaint, the school must provide written notice to parties, and that written notice has to include, first, a discussion of the formal complaint process and an informal resolution option, and we'll talk about informal resolutions at the end of the presentation. A sufficiently detailed statement of allegations. So here the regulation says sufficient detail includes the identities of the parties, if known, the conduct allegedly constituting sexual harassment, and the date and location of the alleged incident, if known. So here the idea is you want to give the parties the benefit of information so that they could prepare a response and kind of know the allegations against them before they come in for this interview. Next, a statement that the respondent is presumed innocent, we talked about earlier, and that the determination of responsibility is made at the conclusion of the process. So that needs to be included in your notice. Next, a statement regarding the right to an advisor and review and inspect evidence. And last, a reminder that the school prohibits knowingly making false statements or knowingly submitting false statements. So we talked earlier, the parties have to be provided sufficient time to prepare, and we'll go through those timelines a little bit later. And an important point is, if in the process of your investigation, you decide or determine or find new evidence that a new potential violation of policy that you might want to pursue, you have to provide an updated notice that the school decides to is pursuing that, and with the sufficient detail that's required for the student to be able to prepare adequately for this new allegation. All right, next, so confidentiality. So the requirement here is that schools have to keep confidential the identity of an individual who's made a report or complaint of any sex discrimination, including reporter, respondent, or witness, for 3 exceptions. First exception is as may be permitted by FERPA. So FERPA is the privacy law that governs institutions of higher education. So if it's permitted, this confidentiality does not need to occur. Second is required by law. And third, most relevantly, to carry out the Title IX regulations. So having a investigation, hearing, adjudication, obviously you're going to have to name parties and incidents that occur that may be protected by confidentiality. And here, this is saying that this doesn't apply for the purposes of carrying out this regulation.
And Scott, it's probably fair to say that confidentiality concerns, I mean, for investigators, adjudicators, I mean, everyone, it's important to be really mindful of confidentiality overall, right? I mean, the sort of rule that we've noted, rule of thumb that we've noted in other presentations is to always try to keep things as confidential as you can while doing the job. But when you get to these specific issues around FERPA, et cetera, I mean, the right person on campus to answer those questions, if you have a FERPA officer, but otherwise counsel, et cetera. My point is, there's not an expectation, for example, that investigators, adjudicators, or others will necessarily become experts in FERPA. But what they should do is be aware of this requirement and be ready to talk with Title IX coordinators or counsel if they have questions around these kinds of issues.
That's a great point. Yeah, no one can be an expert in all these pieces and nuances. So you definitely want to seek help whenever you have a question. So here, let's talk about access to evidence requirements. So here we're going back to the touchstone of equal opportunity equity. The regulations explain that institutions must afford both parties equal opportunity to review and inspect evidence that was obtained as part of the investigation and is directly related to the allegations. So here, the regulations specifically use the term directly related rather than relevance. So at this point in the process, directly related is kind of a broader universe of evidence than relevant. And parties need to be afforded an opportunity to review evidence that's directly related to the allegations. Relevance decisions are made later as we talk about, and as the slide notes, this includes evidence which the school does not intend to rely on in reaching a determination that could include relevant evidence and inculpatory, exculpatory evidence as part of it.
Susan, I'm just curious before we go on to the next slide. One of the things that this raises in my mind is the logistics of managing an investigation. You could have at any time a complainant or a respondent ask for access to evidence. You might have people call you back up with more questions. You may have follow-up questions. Presumably you're trying to stay in contact with the Title IX coordinator and other appropriate parties. It's a lot, I think, to take in and to be prepared to manage, particularly if you're being asked to sort of step into the role as a Title IX investigator and it's something new for you, or even if you've done it once or twice, it's still a lot. I'm just curious if you could comment a little bit on how you manage investigations and how you work with schools or businesses or organizations when you're in this process. I would think Title IX investigators at a campus are sort of like outside counsel in the sense that there are others at the institution who are more involved in the process that they've got to work with, HR, counsel, et cetera. How do you sort of manage all those logistics and approach all of that?
I wish I had an easy answer for that because it can be a bit of a circus. The reality of the situation is that you have to manage it. You can't allow it to run off the rails and let any one party kind of take over it. So having an even hand and appreciating that this is very emotional for all parties involved is important, and treating it with the dignity and respect that it needs. So making sure that there are clear lines of communication, making sure that everyone here feels that they've been heard as part of it, keeping people up to date on the status of the investigation so that there isn't any sort of confusion or ambiguity about where we are in the process. I think that's extremely important, and oftentimes will alleviate the chances that people will be bombarding you with questions and demands for information on any sort of regular basis.
Yeah, I guess my takeaway for folks, if you are a faculty member, a professor, someone who being a Title IX investigator is not your full-time job, I mean, I guess my follow-up to that would be, if you're being asked to be an investigator, at least for the period that you are in that role, it is serious business, and it's probably going to require a great deal of your time and attention. And you've got to invest that time and attention to make sure that it gets done right. So your school's asked you to do something pretty important for at least the time period that you're acting in that role. What do you think, Scott? Next slide.
Sounds good to me. So here it kind of lays out the touchstone of access to evidence is providing this access at reasonable times in order to allow people to respond meaningfully. But there are specific timelines and deadlines in the regulations that they should be aware of. So generally first, you have to provide access early enough to make sure that each party can meaningfully respond prior to the conclusion of the investigation. So that's something that kind of should be in the back of your mind. But prior to issuing the investigative report, the investigator must send parties all evidence subject to inspection and review and afford at least 10 days to submit a written response. So this is prior to the investigative report. You have to build in a 10-day process to submit written response. Next, 10 days prior to the hearing or other determination, you have to send the investigative report to the parties for their review and written response. And last, at or during any hearing, you must make all evidence available to parties and afford equal opportunity to review that evidence, including for the purpose of cross-examination. So to the extent that you're developing your process now, make sure you consider these timeframes and the general kind of approach to the evidence here to make sure that you have sufficient time to meet these requirements. All right, so next, serving impartially. Let's talk about that. So we introduced this at the beginning. Investigators can't have a conflict of interest or bias for or against complainants or respondents generally, or an individual complainant or respondent. So very high level terms, this means that your investigator can't have a general bias or conflict against everyone who's a complainant or everyone who's a respondent, anyone who is involved in an issue of sexual assault generally. But also to make sure that the investigator doesn't have a conflict or bias against the individuals they're investigating. So at the outset, you want to make sure that your investigators are free of conflict and can objectively evaluate evidence for these really sensitive situations, but specifically just to make sure that for each case they investigate, there's no conflict or bias. As we mentioned, investigators have to objectively evaluate relevant evidence, and they have to be able to do that. They need to be free of conflict and bias.
Susan, I and Scott, both of you, I'll open this question up because I think this is trickier than it sounds, right? In my mind, if you are Ohio State, I always use Ohio State as my example for a big school, Ohio State or the University of California or UT Austin, it may not be that difficult for you to find investigators who have no relationship at all to the respondent of the complainant. But at small schools, and there are thousands of small schools, Title IX applies not only to, the big state institutions and the elite Ivies, but every institution, regionals, small faith-based institutions, career schools, even Miss Betty's Beauty Academy down the street. So you could have institutions where it's very difficult to find a faculty member or an employee who doesn't know virtually every student or every other faculty member. And my question to you is, when you're thinking about this requirement, I mean, at what point does an investigator have to say, look, I know I'm a faculty member. I know, but I'm not in their department, but I know both these guys. I play golf with Jim, and my wife and I play bridge with Jane and her husband, and I'm not sure I can do this. How do you make that decision? And particularly in a smaller school environment, where do you draw the line? Because I'm concerned that there will be institutions that have a really hard time finding individuals who don't have a conflict of interest. And maybe that's when you start looking to consortium arrangements or outside counsel or consultants, et cetera. What are your thoughts on that?
I would completely agree. And I think this kind of training is a great place to start so that investigators know that they have this obligation, but also the right to say, I just can't do it. I know that I just can't be completely and totally unbiased. Either I know these people, or I know that the complainant has made similar allegations in the past, or I know that the respondent has had allegations made against him or her in the past. And knowing that they have the right and the obligation to speak up and say, I just don't believe that I can be truly impartial, is vitally important. And you're absolutely right. That's where I come in, or any sort of outside service comes in to say, okay, then this is one where we do have to go outside of the institution to ensure that the investigation is done with the level of impartiality that it deserves.
And I'll just add quickly that it's really incumbent on investigators to know this and make this decision at the outset, because it's a lot better to know this at the start before an investigation starts, where you could kind of plan accordingly, than after the investigation has been completed and you're in litigation or review by the Office of Civil Rights. So Susan, this kind of gets to some of Aaron's questions, but really to button up specifically, first, what does it mean to have a bias or conflict of interest for an investigator?
Great question. And much like many of my other answers, it means a lot of things. And it means that we're constantly having to be cognizant of our own prior experiences and history as we're going into things. But from a very high level, it means that we need to avoid any prejudgment going into the investigation. We can't make a determination before we've heard the evidence. We can't make inferences based on the gender of the person who's making the complaint or the gender of the person who's the respondent. Just the avoidance of those stereotypes right out of the gate is exactly what we're talking about when saying that an investigator needs to come into these without any sort of bias or conflict.
Yeah, and I'll just quickly add that the preamble explains that a prior op-ed or participation in a certain group, say for example for men's rights or women's rights around this issue, does not automatically disqualify a person. You really kind of have to get into the nuts and bolts here of how this person responds to the situation and whether they do have a conflict. So just affiliations, just want to make clear, are not sufficient in and of itself. You really have to go into specifics of each individual. And we talked about how investigators can kind of make decisions and kind of let institutions know they have bias. What can an institution do to make sure that investigators remain free of bias and conflicts?
Yeah, again, I think this type of training and trainings like it are vitally important for institutions to be providing to their investigators so that they know what their rights are. They know that they have this duty and right to say, I can't do this. They shouldn't just be told that because they've been selected as the investigator, they have an unfettered obligation to follow it through. So institutions getting out in front of this and making the rights of the investigator clear is important and a wonderful first step. And then the follow through on the institution's part to say, we won't penalize you. And in fact, do not penalize those who come forward and say, I cannot do it. I just simply cannot be unbiased, or I have a conflict of interest. I do play golf with the respondent, or I have been involved in other investigations myself involving this complainant, things like that. Practicing what the institution preaches is vitally important so that it's clear that if an investigator does step forward and say, I do have a bias, there won't be any retaliation or retribution against that investigator.
Yeah, and I know I'll just add for the smaller institutions that are listening to this and thinking, well, wait a minute. I mean, if we train 2 or 3 investigators and they're all conflicted out because everybody knows everybody, does that mean we have to go outside every time? Maybe, but what I want you to know is it doesn't necessarily mean that there are a lot of folks thinking about this issue right now. I know that there are some school associations that are talking about consortium arrangements. That's been out there in the ether and part of conversation for 4 or 5 years now. And there are a few examples already. I think with the advent of this new rule, there's going to be a lot more momentum around getting groups of schools together so that, for example, you can create a pool of investigators and without having to, with all due respect to myself and my colleagues, hire expensive attorneys every single time you have a formal complaint of sexual harassment. You know, what you can do is potentially go to another school in your athletic conference or in your region that has some Title IX investigators, and you all just agree that you may trade personnel to avoid conflict of interest type issues. So I think there are some creative arrangements out there that are being formulated, and I think that's a really good idea. There are situations where because of the stakes or the severity of the issue, you may well want Susan or some other attorney to come in and run point on an investigation, most certainly. But there are also going to be complaints, formal complaints of sexual harassment where you really don't feel like you need a professional investigator, but you have trouble with the conflict of interest question. And that's where that consortium type arrangement could be really beneficial. So we support that. And I hope that schools will continue to work with other schools to find efficient ways to take into account the conflict of interest concern without busting the budget as well. I think they will.
Perfect. And last, Susan, we've talked about this concept a number of times, inculpatory and exculpatory evidence in terms of evaluating relevant evidence objectively. Can you just explain what each mean and how they would come up in the investigation?
Sure, absolutely. And these are legal terms that don't often trip along someone's tongue. So I appreciate that we need to level set a little bit on this. Inculpatory evidence by definition is evidence that shows or tends to show the respondent's responsibility, and conversely, exculpatory evidence is evidence that tends to show that the respondent is not responsible. And the bottom line here is that it's all going to have to be assessed by the investigator. An investigator cannot, must not only look to inculpatory evidence and exclude exculpatory evidence, and vice versa. As we'll see when we're talking about the report and credibility determinations, the report really needs to take a look at both types of evidence when proceeding through the investigation.
So let's dig into a topic that we've talked about throughout the presentation and really kind of dig into a little more detail, and that's issues of relevance. So here, this is especially important because the main product of the investigator is to create that report for adjudicators to consider that fairly summarizes relevant evidence. And we'll dig into that in a little more detail, but first wanted to touch on one point that's made explicit in the regulations about what is not considered relevant evidence. So the regulations state, and for those of you familiar with legal concepts, this is kind of a rape shield rule that the department included. but evidence about a complainant's sexual predisposition or prior sexual behavior are not relevant unless, and I'll read this because it's important, such questions and evidence about the complainant's prior sexual behavior are offered to prove that someone other than the respondents committed the conduct alleged by the complainant, or if the questions and evidence concern specific incidents of the complainant's prior sexual behavior with respect to the respondent and are offered to prove the concept of consent. So generally, evidence about the complainant's sexual predisposition or prior sexual behavior are not considered relevant, except for these two narrow exceptions. And for all of the adjudications that I've been a part of, this issue comes up fairly rarely, but it is very nuanced. So important to know this exists, important to have an understanding of it, but it is a concept that kind of threads a lot of needles. So to the extent that you need to if this comes up, think it through or ask for help, this is one of those times that you might want to do that. It's an important concept. So let's generally talk about relevance, Susan. What is relevance and what is relevant evidence? That's a foundational concept. We want to make sure we understand it.
Yeah, and again, going back to the general legal understanding of the term, because this is not a term that is defined within the regulation itself. The regulation says that the ordinary meaning of relevance will be applied here. So under most rules of evidence, evidence is defined as information pertinent to proving whether information is material to the allegations alleged and whether that information makes the allegation more or less likely to be true. You might say, well, then if I hear that information over and over again, does that make it more relevant? And the answer is no. The repetition of the same information is not going to make the information or the evidence more or less relevant. It's truly whether that information goes to the allegation and making it seem more likely to be true.
And so getting to the responsibility of the investigators, this investigative report that summarizes relevant evidence. So if you're an investigator, you would have evidence that might not be related to the incident at all. You could have evidence that's directly related to the incident, but not relevant, and relevant evidence. And a mountain of interview notes and transcripts and documents, all kind of needing to be synthesized into a coherent structure that is helpful for adjudicators in order to come to their determination. So it's a very broad question, but how do you do that? What's some advice you can give for investigators to make this possible?
Well, and I think you've hit the nail on the head. We want to produce a report that is helpful to the adjudicator. And with that principle in mind, I think it's important that the usage of the information is presented in a way that makes clear to the adjudicator how you went about gathering the information, what steps you took, so that the adjudicator has an appreciation right out of the gate that the investigator spoke to specific people, that specific documents were requested, whether that's texts, emails, any other records that the complainant or respondent may have. Include the alleged incident itself and all the people and witnesses that you spoke to. Highlight any key factual findings that you attained during your investigation. Specify the relevant evidence that was looked at, whether that be conversations or documentation, and then lay out the specific policy that is alleged to be violated. I think if you're guided by those pieces, it'll help form the narrative that will provide the adjudicator the information that's necessary in order to determine what information was relied upon and deemed relevant.
And it's very, I know we're giving folks a lot of detail here, and there are a lot of details. There's a lot to absorb, and over the years, if you are regularly serving as an investigator, you'll get better at sort of absorbing all those details and putting them into practice. But, Susan, as I listen to you and Scott, it seems to me that, if I'm new to this, what are the things we should be telling a brand new investigator? And in my mind, the sort of high level ideas are be objective. That's really important. Be careful. It is important to be careful. And then when I look at this, it seems like it's important to remember too that at the end of the day, what you're trying to do is provide the information that will allow the school to get it right. So when you're thinking about what's relevant, you know, the ultimate objective of the institution and if you're an investigation is to try to figure out what really happened and to come to the right and just conclusion. So evidence that helps you do that is relevant and appropriate evidence. And you know, I fear that folks are going to get so weighted down and concerned with all these details, and the details are important. But it seems to me it's important to also keep in mind sort of the high level philosophically what it is you're really here to do, and that is to try to get to the right answer.
And I think that's absolutely right and needs to be sort of the level set here. What will often happen, again, because we're talking about humans, right? We're talking to humans about a human interaction. When you're speaking to a complainant, a respondent, and the witnesses, it's not uncommon for any one of those people to decide to share everything that's happened in that person's relationship. And as the investigator, I find it helpful to allow the person to speak, right? You don't want to cut them off. You don't want to deminimize their experience. You don't want to put them in a defensive position. But that doesn't mean that everything they have to say should end up in the report or is relevant. So knowing that you have to continue to come back to the policy that's alleged to be violated and the incident itself and let that be your touchstone, even as the person might be veering off path and oversharing, is really going to be a helpful level set throughout the whole process.
Yeah, that's great. Great advice. Great advice. Interviews.
Yeah. So let's talk about interviews. And I think the first question we have for you, Susan, we already touched on. So if you have anything else that you maybe think of in terms of which individual interview, we'd love to hear that. But really, just once you have determined who to interview, how do you determine what to ask them? You mentioned before you want to put them at ease. How do you do that? How do you make sure that the people you choose to interview, you're getting the information you need from them? That'd be helpful.
Yeah, and real quickly to go back up to the first question, the one thing I think is important and maybe obvious, but maybe it's not, you really need to ask both the complainant and the respondent, are there any people that you think would be helpful to this investigation for us to speak to? Because if you're only asking the complainant that, you are right out of the gate invalidating the investigation. It's very possible that the respondent has witnesses themselves that will be key to that inculpatory and exculpatory evidence that we've already talked about. But once you do have that list, I like to tell anybody that I'm training and certainly utilize this process myself. Number one, come prepared. You know, don't go into it blind. Although, sort of the countervailing principle to that is if you apply the funnel method, which I'm about to describe, you could go into it cold and still get out really great information. So the funnel method is just that. You start out very broad and go more narrow. So if you start out your investigation by asking the complainant, respondent, witness, whoever it may be, tell me what you know. And then letting that guide you in your follow-up questions is a really effective method, because if you allow the person to get their full story out and then come back to the information they gleaned and continue to whittle it down. Okay, you mentioned on such and such a date, this happened to you. And then start getting more and more granular with those questions. Who else was around? Was anybody asking someone questions during that process? Anybody that witnessed this, you know, what was the person wearing? What, you know, just getting more and more narrow as you're working your way through. You will ultimately be able to, at the end of that conversation, say, is there anything else you think I should know? And if they give you more information, you start the process all back over again and really get more and more narrow as you go through the process. As opposed to being so wedded to a script of questions that you're missing out on really being able to hear what the witness, complainant, respondent is telling you and gleaning information that way. More often than not, novice investigators really get thrown off their game if they are so wedded to a script that they're missing out on really listening to what the person is telling you. Whereas if you go in with a very open, tell me everything, and then follow up with specific questions after you hear what they've had to say, I think you're going to get a lot more useful information.
Yeah, and I think that's a great point. All of them are great points, but I think just from a risk management or institutional liability perspective, part of the goal here is to make sure that the complainant and respondent feel heard, feel that they have a fair process, feel that they are not being judged, and that they're being listened to. So I think that approach could do a lot in potentially making them feel that they are going through a fair process regardless of the outcome.
Hey, Susan, Scott, I'm curious. I don't think this is a question we have on our slide deck here, but how important is it, you guys think, to have two people in the room when you're doing interviews, whether that be two investigators or just a second listener with the lead investigator doing the real work? But I know that a lot of times that can be a worthwhile consideration. What do you think?
Yeah, I would definitely agree if it is feasible, that it's very helpful to have somebody in there as sort of the note taker and the listener, whereas someone else is doing the questions. I don't think it's appropriate for both of them to be playing the role of questioner, because then it feels very much like an interrogation, right? We want this to be a respectful, comfortable environment for all parties involved. So I think the roles of the two people need to be very clearly defined and explained to the person from the onset. But I think it is helpful for someone to be in there as a bit of a scribe, so that the investigator, the one asking the questions, really can be having more of an interactive conversation as opposed to, having their head down, scribbling notes the whole time. And then also circling back with that other person before you end the investigation or that specific questioning, to say, okay, is there anything that you heard that I didn't circle back on? And making sure that the two are working together to really provide credibility to the conversation could be very helpful. If it's not feasible, then I think circling back to the concept of bias and impartiality, if in some of those smaller schools it's just not possible to have another person that can be unbiased and impartial and isn't only taking notes on the things that they think is going to help the case, then it's certainly not a requirement, but it can be helpful if it's if doable.
Let's talk a little bit about advisors. We haven't talked about it in this presentation yet, but under Title IX, all parties are eligible to have an advisor of their choice. This could be a parent, a fellow student, a friend, or an attorney. And sometimes when you have an attorney whose job is to zealously represent their clients, even though they might not technically be acting in an attorney capacity here, there could be some difficulties, pushback, overzealousness. Similarly, for a parent who's advising their son or daughter on potentially the worst thing that's ever happened to them in their life, temperatures could be high. How do you respect the role of the advisor, but also make sure as an investigator, you're maintaining order and getting the information that you need?
I think it's important to set the tone right out of the gate that the investigator is the one who's in charge of this. And that needs to be done in a respectful way, but also in a bit of a stern tone that I am the one that will be conducting this interview. I have rules around that. I'm going to clearly explain those rules and expectations to you. I'm going to enforce those equally and really make it clear right out of the gate that this is not going to turn into any sort of circus or shouting match, or that you're going to be the one that's going to be keeping control of the interview. And making sure that is really made clear from the get-go, I think is incredibly important and appropriate, and frankly within the investigator's right to do so. So making sure that that you keep that control, and if necessary, terminate the interview if the advisor is not acting appropriately, is also within the investigator's rights and something that should be done in order to maintain the credibility of the interview.
So I want to turn next, Susan, to the issue of law enforcement. So here we're talking about potential sexual assaults, which is a criminal offense, could be investigated both by the institution and by law enforcement. How, as an investigator, do you, without police power, without subpoena power, handle a concurrent law enforcement investigation about the same topic with the same witnesses and the same evidence?
Yeah, and I think that is an important point, because it's very possible that that concurrent action would create a basis for postponing an interview or seeking an extension under the normal timeline, because you certainly don't want to do anything as part of your investigation that impacts or negatively affects the concurrent law enforcement investigation, especially if that could then if information could be gleaned through the law enforcement investigation, who does have those types of subpoena powers and other regulatory authority that you just don't have, that information could be beneficial to your investigation, and it deserves then the ability to work its way through the process. So I think it's important that investigators think seriously about whether or not they should postpone or seek an extension in those situations.
Right, and I'll just add the preamble addresses this and kind of takes the view of you have to look at the definition of short-term delay under your policy. So to the extent that you have a police matter and you're in contact with an investigator and they kind of say, hey, my report or this evidence will be available in 2 weeks, that could be a reasonable short-term delay. If the thing is, we have a rape kit, it's going to be processed in 1 to 2 years, that might not be a short-term delay. And you might have to kind of go ahead with your investigation there. But make sure that you are in communication, that there is coordination, and that whatever actions you're taking has this short-term delay, this good cause exception to the prompt requirements in mind. So next, talk a little bit about credibility determinations. And we want to make one point about credibility determinations. So here, the decision makers, the adjudicators, are the ones that have the determination to ultimately make their decision. So it really kind of puts investigators in a interesting position, because what do investigators do in terms of a report to be helpful, but not to kind of prejudge a situation for an adjudicator? Credibility, we want to first make clear that an investigator can make a credibility determination if they choose to, but under the following caveats. So first, credibility determination can't be based on party status. And second, the investigator's determination regarding responsibility, regarding credibility can't be a determination of responsibility. So you can't kind of prejudge a situation as an investigator that would kind of lean a decision maker to kind of make one point or the other. So that being said, it's up for an investigator, up for schools to determine whether the best and highest use is to report the relevant evidence as is required and kind of leave it at that, or if there are some credibility judgments that they want to include within these specific rules that would be helpful for adjudicators, but also would not be taking the place or responsibility of an adjudicator here. And now let's turn to the collection and review of documentation. So here, as discussed in the previous presentation, records of each sexual harassment investigation need to be kept for 7 years. And so while investigators might not be responsible for maintaining records, a lot of the records they're producing are those required to be kept under the regulation, under law. So it's important to be aware of what records are required to be kept and make sure that you're providing those to the appropriate party so that they could be stored in case of further need in the future. Susan, I'll turn to you. Just curious about some best practices for review and collection of written documentation.
Yeah, I think keeping a transcript both of your own written requests for information and any requests for witnesses and whether the witness was willing to cooperate or not, you know, really keeping a thorough set of your own notes and any requests you made is vitally important. As you become a more seasoned investigator, having sort of a template of your regularly requested information is very helpful, because then that also shows that there's nothing unique or potentially biased about any requests you have for this investigation. And then making sure that you are retaining that information that is produced in response to your request is helpful. I'm sure it's tempting to take audio recordings of any interview so that there's no question about what information is gleaned. I would only add on that note that we take into account state law, depending on where you are, as to whether or not you need 1 or 2 person consent for those kind of recordings, so that we're not stepping into some other issue then of relying upon that audio recording in the future.
Perfect. And as an investigator, in the moment, what should they be considering or just have in the back of their head about potential litigation or audit or things of that nature?
I think it's important to be thinking about potential litigation or audits, and just know that that is something that could come out of your investigation and the adjudicator's determination. So as you're putting your information together, as you're taking your notes, as you're making your requests, it's helpful to be guided by the thought of how is a judge, a jury, an administrative agency going to look at my notes. And as we've already discussed, credibility determinations don't necessarily have a place in the investigation. So if in your notes you are making comments about this person does not seem credible, that's going to be an issue potentially going forward. So being guided by the concept that your notes might very well see the light of day is helpful. And then again, the concept that your documentation, your investigative notes, any requests need to be retained for at least 7 years is something that you should be thinking about when you're putting together your information, such that if something is referenced in your notes or in your transcript, and then that information is not readily available, and the case does go to litigation or audit, you could be looking at a potential destruction of evidence issue, since you do have that obligation to retain the information for 7 years.
And so moving along, for investigative reports, and this question kind of dovetails nicely into your last answer, but when you are writing an investigative report, along with litigation and potential audit, what are the main goals? What do you want to include? What's important for you to have for both the adjudicators to find helpful and for the institution to kind of have on record?
I think it's important to remember what your role is as the investigator. Your role is not to come to conclusions, and your role is not to make your personal opinions heard throughout this. Your role is truly to be a repository of information and a explainer of what information you obtained. So taking a step back when you begin to cultivate your report, and think in terms of, if this becomes the first exhibit in a lawsuit, what do I want it to look like? What do I want it to provide? And how am I going to best represent this institution that has hired me or appointed me to do this job is really key. So think in terms of what the allegations are, what the policies are that have been violated, and how best to encompass all the information that you've gleaned so that the adjudicator or an audit committee or a judge and jury can benefit from the information you've obtained.
Perfect. So I think that's perfect. And with that, we're going to switch gears from the investigation piece to informal resolutions. So I want to just make sure we understand we're kind of taking a hard break and pivoting, and we kind of concluded the investigations piece and are talking about informal resolutions here, particularly because we want the benefit of Susan's expertise in having kind of gone through these resolutions and mediations in the past. But this is not a concept it's related but not directly tied to investigations. So starting anew, informal resolutions. So under the regulations, a school may not, well, first of all, informal resolutions are an option for schools. So if a school does not decide they want to have an informal resolution process, it's not necessary to include one. But to the extent that one is included, the school cannot, under any circumstance, require that student or employee to waive the right to an investigation or adjudication under formal complaints of Title IX. So there should be no kind of pushing people into this option. This is something that could be very beneficial to both sides if both sides are willing participants and not kind of coerced by the school to enter into this. I think so the schools can't.
Yeah, I'm sorry, I don't mean to interrupt, but just real quickly, in case people aren't, haven't thought through this or haven't been a part of these kinds of processes in the past. I mean, why would a school want an informal resolution process? I mean, what's the benefit there as opposed to going through a full investigation and a hearing?
Absolutely, that's a great question, and I might kind of step on Susan's toes a little bit for a post slide, but really, an informal resolution is a process that would avoid all the process and the trappings of a formal adjudication. So it's more relaxed. It's kind of you can more determine the outcomes. The stress levels might not be there for the parties. And hopefully it could be a way to kind of accomplish everyone's goals in a less intrusive environment.
Very good.
So a couple more details about the requirements for informal resolution. So the school can, as choice, facilitate informal resolution that does not involve the full adjudication and investigation. Provided a couple conditions. First, you have to provide the parties a written notice disclosing the allegations, the requirements of the process, the circumstances under which the process precludes the party from resuming a formal complaint, any other consequences of participating, and records that will be maintained or could be shared. You have to obtain the party's voluntary and written consent before entering into the informal resolution as well. Last, informal resolution is not available to resolve allegations that an employee sexually harassed a student. The department said this is not an appropriate vehicle for that for a number of reasons. And maybe one of the most important points here, even if you enter into the informal resolution process at any time prior to agreeing to the resolution, any party has the right to withdraw from the process and resume the formal complaint process. So just because you start down this path does not mean that you can't pull the plug at really any time, and schools have to be aware and upfront of about that, and parties need to understand that this is their right. So Susan, I touched on a little bit of these pros and cons before, but as someone who has a lot more experience than me with informal resolutions, what do you see as the pros and cons of each?
Well, I think one of the biggest pros, in addition to everything you've already said, is that there is a certain level of control that both parties retain in the informal process that simply are not present in the more formal process. Once the formal process gets underway, as we've already seen throughout both this training module and the other two, there is a formal process, and you really don't, as the complainant or as the respondent, have a whole lot of say in how that plays out. You have very little, if any, say in who the witnesses are, what the information, what the documentation is that the investigator is going to ask for and review. Whereas in this process, you do have more control over that, and that could be desirable for either party depending on what the issues are. And certainly then as the process plays out, if we get to litigation as part of the process, any modicum of control goes out the window. Whereas in an informal process, you can have more say in the timing of things, more say in what the outcome and what the potential discipline might be as a result of the complaint. Conversely, though, if this is all unsuccessful, if we can't reach any sort of resolution through an informal process, you've essentially kicked the can in the down the road for the formal complaint, because then we'd have to start the formal process if the informal process proves unsuccessful. So if the goal is to get this done and move on with one's life, it's possible that this will prolong that. Of course, it's possible that it won't, and litigation would certainly keep this process going much, much longer. You also have fewer safeguards around it. So while you have a right to an advisor through the formal process, you might not during the more informal process. And so I think the name of the game here is that when deciding whether or not to go with the more informal process, more of the mediation concept, be fully informed of all your rights and the rights that you're giving up by going through that more informal process.
Perfect. And then I think my last question for you, Susan, for this presentation. So schools could provide a facilitator to facilitate informal resolution, and if parties agree, it could be a good option for all the reasons you outlined. What's best practices for facilitating informal resolution and selecting a person who would be good in this role?
I think there's a lot of overlap between best practices for the informal resolution and the person who's going to facilitate that, as there is for the investigator in the more formal process. You really need, as the institution, to be intentional in who you select, and not just someone that seems to be available at 3 p.m. on a Monday. It's got to be somebody that's been trained in how to do this, who is neutral and hopefully unbiased, much like the investigator themselves, so that it's successful. Because if you put someone in that role who is totally untrained and might be known to one or both parties, the entire process is going to fall apart. So I don't want any institution to take away from this that the informal piece of it means you don't have to be formal in the structure of the informal process. I think to that same point, the neutral trained facilitator really needs to explain the process and the benefits to the informal resolution to the parties the same way they will explain the process in a more formal setting. A fully informed informal process is key to this, to the success of the process itself. And yet also that same person that's fully informed also needs to be compassionate, empathetic, and kind to all the parties in order for everybody to feel comfortable really engaging in the process. So striking that balance of a well-trained and neutral facilitator with someone who's also compassionate and kind is going to be key to the success of the process. Couple of the things that you can be mindful of when helping the parties reach a settlement is what the ultimate goal is. If the ultimate goal is to be able to continue to engage and interact with one another, things like counseling and dispute resolution training, ensuring that there's repeated touchstones with those two individuals, so that if things are not going well in the weeks and months in the future, the institution knows about it before it reaches the point of another complaint. changes in the schedules of the two individuals so that you can ensure that the individuals are not coming in contact with each other. All of that should be on the table and included when trying to reach an amicable resolution of the complaint.
I think those are all great points. I just last point to add. In addition to what you laid out, it's clear that disciplinary measures against the respondent can be part of an informal resolution.
This brings us to resources, and we'll go quickly through this last little bit. I want to thank Scott and Susan for being a part of this. As always, so much appreciate you being on the higher education team and working with institutions of higher education in addition to all the other work that you do for the firm. We have a couple of things. Let me go back. I actually skipped a slide. I want to make sure to hit this one. So the Office of Civil Rights has a blog. You could Google Office for Civil Rights blog if you wanted to, or if you have the actual slides from this deck, you can click on that and it'll take you there. But OCR has made clear that as they go forward with interpreting the new rule, they will post a lot of their guidance and thoughts here at this blog. So if you are at the school and you're curious, and certainly if you're counselor or Title IX coordinator, you'll want this particular link in your favorites in your browser. We have prepared a comparison showing the changes that the new rule made to the existing Title IX regulation. That's also available on the same page where you'll find the slides. So if you're the kind of person who, like me, really wants to see with some precision what was changed by the new rule, this will be a very helpful tool. We have a webinar series just for higher education. It starts typically, tracks the academic year, starts in the fall, goes through the spring, and we cover a lot of topics, Title IX and others you'll see here. In May 2020, we actually did a 3-hour presentation on the new rule, which was sort of the seed for what became this training series. We also have a blog that we would be delighted for you to check out. And then we have, let me see, there's the blog. And it's Regulation. I don't know. Some people seem to like that name. Some people not so much. My wife is not a fan. But we write about higher education, regulatory and policy issues. And then finally, I'll note we do occasionally put out free things like our bar defense reporting guide and other tools for institutions to use. We will, and you'll see after I leave here, I'll include just some final slides with some additional biographical information for Susan, Scott, and myself, and our disclaimer, which at the end just points out that we're not your attorneys. If you've made it through this presentation, good for you. It's one of the longer and more complex ones, and we're glad you hung in there. We hope you will take the time to check out some of the other modules, if not all of them, in the training series. And with all of that having been said, I'll just say from Susan and Scott and myself, be safe and be well.